we going to be able to wholesale in North Carolina or not? That's the question. Attorney Stephan Hegedus breaks down House Bill 797. It is the residential wholesaling protection. We need to know these answers. A room full of experienced investors spend an hour asking questions, getting answers. If you do any kind of real estate in North Carolina, you really need to listen in, and don't forget to subscribe. We're going to follow this bill along and figure out what we can and can't do. Listen in.
So I'll just start off by going over the bill itself. Everyone probably saw that there's a date on there saying that this took effect October 1st, 2025. It did not. Okay, it's still in the Senate. It made it past its first reading, and it got sent over to one of the many committees where it's now sitting. It would have to both pass the Senate in its current form. It's already passed the House. If that happened, the governor has made no issue in saying he would sign it, effectively changing the way who can do assignment contracts and how they're done. Something similar happened in the late 80s to what's called contract for deeds. They also went through this thing, and it pretty much made them very hard to do. And I feel like this law is going to do the same thing for assignments. The first thing it does is it really does three things. And that first one is to say, who is allowed to do assignments and what is an assignment? It effectively says, if you as an individual that's not a broker sign a contract with someone else, in order for it not to be considered an assignment or underneath that umbrella, it has to be a home you're buying from someone else to live in as your primary residence, not to buy and resell. It makes that distinction. And it also says that anybody that is doing assignment contracts, buying the property with the intention of assigning the contract or flipping it and assigning equity in the property is now a broker activity, meaning it falls under the real estate commission, meaning you would have to have your real estate license or be under a broker in order to do those contracts. That means if you tried to do it as a private person without a brokerage license, you would then be subject to the rules of the real estate commissions as unauthorized practice of real estate activity.
I do got a quick question.
Sure.
So, can you still do a novation, or is it anybody who gets a fee on HUD?
I knew that question was coming up, and I looked at novations just to make sure. They're very specific in any kind of selling or purchasing or anything like that. So if you were to get a contract, do a novation and get paid for that, that is the same thing that would be covered under this bill.
What's a novation?
A novation, okay, so an assignment of contract is a signing of benefits, right? So if you get a contract and you assign it, you're assigning the benefits, but you still have the responsibility under the contract to perform. That's why you can take the contract back if the assignee doesn't end up following through and then reassign it. A novation is the cancellation of a contract and effectively creating a new contract between the seller and now the new buyer. It becomes an A to B replacing B, where an assignment is an A to B and then assigning it to C as a new buyer. So in my reading, interpretation of this bill, and what people talk about novation, I would say that a novation would fall under this and it would be considered a brokerage activity as if you got a fee for it.
Let me ask you this too. I got some deals too. Actually, it's quite often where instead of assigning it, I don't really like assignments. I know this guy really well. I've done a lot of deals with him. I'll just put his company's name on the contract. I did the deal, but I'll put his company's name on the contract. HUD, whatever I was going to make, he'll pay me the finder's fee, and he's never undercut me one time or another. Would that be an issue?
That would be under Section 832, marketing, assigning, or selling, or purchasing contracts for a residential property.
Motherfuckers,
Yes, because you're probably marketing, doing items that would fall under that service. So they're getting rid of finder fees, they're trying to get rid of assignments, anything that has to do with it. And the way it's currently worded, I am unable to say for sure that it could not apply to double closings. I don't think it would apply, but technically it might because it says in section 833, selling or buying or otherwise dealing in residential property for the equitable interest in residential property. So that means if you sold or bought anything within a property, even in a double closing, it could apply. I don't think it would, but I can't rule that out in the future. I was talking to one of my colleagues today, and he said, well, if anybody's worried about that, tell them to wait 3 months after the bill passes, and you'll find out someone else will do it. So,
Stephan, what is the genesis of this law? Is it a law or is it a rule?
it is a bill, it's not a law, so it's still pending within
But after the bill gets passed, then it's a law.
It would be an amendment to the current law, yes. So it affects section 93A2, which is what controls the real estate commission and real estate brokers.
Which question is that?
The Real Estate Brokers Association, the Real Estate Commission and Association of North Carolina.
Because they're like one of the largest lobbyists in the country, right?
They are the largest lobby in North Carolina.
And they're doing this is this similar to what they're doing in South Carolina already?
I'm not sure what's happening in South Carolina.
I think, so what they already pushed, like, it's another state that they have to, where you have to, like, they give you like 30 days and the seller can back out of the deal, and before you actually put it on the contract, you have to let them know that you're wholesaling it, and then it can go through.
Okay. So I can tell you what this law does. It is very similar. It's probably already got the idea, yes.
I just wanted to know, so do you need like a real estate agent or something?
In order to do an assignment contract, you have to be a real estate agent or real estate broker, or an agent under a broker, yes.
And if you're neither and you have the intent to purchase, how would you get under contract and then?
If you are using your own funds to purchase the property, you probably do not fall under this. So you can do a double closing.
Oh, yes.
So what that means is, I want to make sure I'm very clear on that, is A to B, first closing, B to C, second closing. You cannot use C's funds to sell to you to purchase A's property.
That's been illegal for some time though, hasn't it?
It's not illegal, but you won't be able to find any attorneys that can do it legally without being disbarred. Yes.
So I started my wholesaling with mobile homes. Now does
You're
that
just selling the mobile homes or
Yeah.
property with mobile homes.
well just somebody that's want to sell, get on the contract and find a buyer.
For a mobile home by itself. Okay,
But you know those are different because those kind of are titles like cars.
correct.
So does that fall? I know it's kind of two different.
That would be two separate things, that's right, yeah. So personal property is like selling a car versus selling a piece of land. As long as you have a title for it, it would be considered that.
So you think that this will take effect in like, they're saying it's gonna take like 3 months or?
Before it becomes law,
Yes.
I have no idea. It's stuck in committee right now, so we'd have to wait and see what the Senate decides to do in their committee before it would reach its second reading. We have to pass 2 more readings, have a vote, and then be signed by the governor. So you're probably looking, I would say maybe end of year, early next year.
How would that apply to land? Because you said you have to have the intent of making it your primary residence.
That's right. It still applies to land. It'd be buying it to build your build a house on it. Okay. Yeah. So anything that can be or is residential property. So if it's zoned residential, it would fall into this. Would not affect commercial property.
So you can assign commercial property?
I believe this only applies to residential property. That's right. Because
So
the
land.
Because
way
it's the realtor, that makes sense, this kind of makes sense.
that's right. Really, as attorneys say, the commercial is the wild, wild west. So if you're buying commercial property, it's whatever goes. There's not a lot of rules that affect commercial property.
What about land?
Land it depends if it's residential land or commercial land. It's all about zoning. So if you could build a house on it, it's residential. Okay. Any other questions?
So bond holding basically, this is not really going to apply to you. If you actively looking, you find that for you to hold yourself.
No, it does not apply to you. You're a personal buyer. You still have the right to make contracts, so it would not apply to you.
Okay. So I know that wording says primary residence, so would they ever look at it as if you buy and you would have to live in that house?
No, in my interpretation of the bill, it would not apply to you buying land for your personal use or resale.
And the same with the home as well.
I'm sorry?
Same with the home as well. is it?
Same with the home. Any residential property where you could build a home or there's a home on it, you can buy personally and then resell as a double closing.
Okay, so there wouldn't be like a cooling off period that you would have to own the property for X amount of days?
Great question. I did say that there is a section, section 833, which sells selling or buying equitable interest in land. So I don't think it's going to apply, but the law in the bill itself is not clear. To me, it sounds ambiguous and unenforceable if it would apply to double closings, and I think that reaches too far what the bill would say. I would say it's probably not going to apply, but if you're thinking about doing something like that, selling and flipping in one day, double closing, you might want to wait 3-4 months after this bill to try to do that to be safe. But I don't think it would apply.
You're not allowed to market or do anything with it, right, until you purchase it. Is that true?
I think that's what it seems.
I think that's the
No,
intent
I
behind it.
don't think that's the right interpretation. I think the interpretation is if you're doing a back-to-back closing, that is not covered under this law, under this bill. I think you could purchase it and then sell it. And I think there's a certain way you have to do it to keep yourself safe from being held under this law. I'm going to go over a little bit more about what the law says because it doesn't keep you from doing assignments, right? It just says you have to be a broker and you have to have certain language. So if you went out and got your real estate license, right, and we're under a broker, you can technically still do assignments. Yes.
What about if you have a unicorn?
A unicorn?
Yeah, like a real
Then you should
estate.
sell its blood, because I think the unicorn blood is pretty
No, like an agent that's, investor friendly, right? And
Okay.
you were friends with them and you just gave them a commission or something. And they were the ones that were negotiating on your behalf. Is that,
If they were the ones signing the contract, technically, you would have nothing to do with that, and that would be a separate deal between you and the real estate agent. But you could not be on the HUD. You could not be on the settlement statement, because that would be a finder's fee for business. Yes.
What's the people, is it gonna be a fine, or is it going to jail, or felony, or, I mean, what's the?
Sure, so,
What's the word?
sure, yeah.
What happens?
I can take a hand smack.
So let's go over, I'm going to tell you a little bit about what the law requires in order to do an assignment if it were to pass. So those requirements are that you have to be a broker. You have to put in 14-point font that they have a 30-day rescission period, that they are not liable for any damages or money spent. If they decide to have to take opportunity of that rescission, any due diligence or earnest money you pay to them, they get to keep.
That's
Regardless.
bullshit.
Yeah.
That's in law.
I'm part of a group, we have a lobbyist that's lobbying this firm.
Yeah.
Or this bill.
Mhm.
They are changing the 30 days to 7.
Okay.
So, not that but it's better than,
7 days, that's right. So they would have a 7-day rescission period where you could then give them their money afterwards. If they were to sell the property, did they take away the commission to having to be a real estate broker? Okay. So
Can we
then
go
the
back to Carl's point? I think what you were getting at is the right to market. And that's what a brokerage license allows you to do, is to be able to market the property. So as a wholesaler, you don't have the right to market. And I think that's what you were asking, right?
we were told that, and I don't mean to hijack your,
No, please, go ahead.
the NC Real Estate Commission, they want no assignments.
That was
Well,
my
if
next
I was them, I wouldn't either.
Yeah, they want no assignments whatsoever, even from brokers.
Yes, correct. That was my next question to anybody who's a broker in here. Because every realtor or broker I know tells you, if you do assignments as a realtor or broker, you're going to get your license taken.
Yep.
So that was going to be my next question to anyone.
That is not in this rule. It says you have to be a broker.
You just have to be
You
one.
have to be a broker
I guess
or
that
an agent
somewhat
under.
protects you. The law somewhat protects you if you're a broker or agent as well.
That's right. And even with a broker, you have that. In the current form of the bill, you have 30 days of a rescission, which effectively gives the sellers the ability to go out and ask a realtor, can you give me something better for this, or whatever. And then they have to give you notice that they want to terminate, and at that point it's terminated.
Does this only apply to assignments?
Yes.
That's 30 days?
The whole bill really only applies to assignments.
This is just North Carolina, so if somebody's working on wholesaling and they're working in other states.
That's right, it only applies to North Carolina.
What about assignments of bids at the closure auctions?
That is not part of this. This is purely with contracts. Bids are a totally different thing with foreclosures. And I think it's not covered in this bill. This is, because technically you wouldn't be buying it from the seller. It's a court-ordered sale, and that court order would set the price and upset bids as well. So I don't think that would affect the ability of the sellers to get a new understanding of what their property is worth.
So they're not legislating to remove assignments at all, it's just in a specific.
That's right. It's the assignment of residential real estate contracts.
So if you can't double close it,
I think you can double close it.
you probably can.
I think you probably can.
But you have to assign it because it has to be signed as an assignment if you double close it.
We may be saying we may be using different terms. When I say double close, is you have a contract with the seller, and then you also have you yourself as B have a contract with C to sell it to them once you purchased it.
A to B, B to C, yeah.
That's right, with a hard stop between B and C.
I was about to say maybe wholesaling, if you buy it and then like with hard money and then turn around and list it and then get it that way. So that's another way.
That's how you'd have to do it if this goes through and you didn't want to have to touch the assignment rules.
That's what I was gonna ask about transactional funding, but he brought up hard money, so.
So yes, you do like a hard money lender kind of thing, like a temporary loan. I've seen that a couple times already where people have used like single day or 3-day loans and they pay like $1,000 for the use of that loan. It's completely legal. Yes.
So how do you know if the law firm handles those types of transactions? Like,
Well, luckily.
We found one.
Yeah, that's right. It's really just asking. You have to ask them. Say, hey, would you do an assignment sales or do you do double closings? I think most firms would do a double closing. Besides the ones that just focus on like realtor closings and fast and easy ones. It should be pretty easy to tell just by a question of whether it's if they do double closings or assignment closings.
So the easiest way to get around it is either double close or get your broker's license? Then it goes back.
Broker's license does not change any of the rules we just said. You have to be a broker under this rule in order to do assignments. If you're not a broker, you're breaking the law, and you could be subject to treble damages under the Consumer Financial Protection Act of North Carolina. So they could take you to court, say, hey, these people tried to defraud me, and the judge could award damages times 3. And then you'd also have to go, the Real Estate Commission could also sue you for the unlicensed practice of real estate brokering. How am I doing so far? I mean, I'm taking out the side of the street, so. Any other questions about the?
There we go.
So with the rules, I know you said in 14.5, you have to disclose that they have 30 days to back out.
That's right.
Even if you have the intent to double close, that still has to apply.
No, that would not apply, because you're not assigning the contract.
Okay.
You're purchasing it for your personal use, and you're gonna sell it for your personal use.
So that 30-day period would not apply for that?
30-day period would not apply because it's a closed system contract. You are the purchaser, that's it. You have a totally separate contract with buyer C. And so they're two separate things, completely separate from one another. That doesn't matter if it's 10 minutes or 50 days. They're two separate transactions, two separate closing fees, two buyers, or one buyer, one seller each. There's no 3-party system. So think about it that way.
Is it personal use or primary residence? Because my initial interpretation was not being able to solicit to homeowners unless you're willing to occupy it as your primary residence.
So that is so this is very specific in my reading and interpretation to assignments, right? So if you're intending to assign the property, the rules say that has to be done by a broker, and it applies to soliciting. So if you are a broker and you're buying it for your personal property, or if you're an individual buying it for your personal property, as a residence, to be a residence for you, then, you know, you could decide at closing that you are gonna build a home. And then 5 minutes later, you could say, well, maybe not, maybe I'll just sell it. So it's over legislation or overreach for someone to tell you what you can do with your property 5 minutes afterwards. So in talking to other attorneys about this earlier today, we decided that an A to B, pay the money, closing's done, deeds recorded. B to C closing does not fall under this bill if it did pass.
You give a discount for double closings?
Double closings are hard. I charge more. We have flat rates we charge for our closings, whether it's double or single. All closings are different, but they are all the same amount of work, whether they're right next to each other or 3 years apart.
That's where it kind of gets like kind of weird to me, because it's like not the double closes, but like novations. Because you're technically a facilitator and marketer, and then you're working with, you know, a broker or an agent. So like, how does that, you know, how does that like become unlawful? You know, like under those.
So it's not unlawful.
Because it's not an assignment, actually.
That's right. It's not unlawful, but in my interpretation, a novation would fall under this bill because it's almost the same thing. If you get a fee from doing a novation, you fall under this.
Because it's like a marketing fee kind of, or it's...
Yeah, you're marketing or selling the interest in the contract. And you're selling your interest by selling the full contract. You're signing the responsibilities and the benefits in a novation. Whereas an assignment, you're just signing the benefits. In a novation, you wouldn't be able to claw that interest back. You could not, the assignee could not cancel, and then you get the contract back. In a novation, you're out. You're done. You have nothing, no power to do anything once that novation happens. So it's the same thing. It's just an assignment of everything instead of just half of it.
Back to the novations. We've done novations where we've had a contract on a house. We've done work on the house, then put it on the market. Is that going to still fall? And how do I protect that?
For you, the owner of the property?
No.
Then it's it would fall under this because you're marketing, assigning, or selling or purchasing contracts. So there is a contract purchase on there. It's just you're basically canceling a contract and putting a new one in place. So in my interpretation, an novation is just a slightly different form of an assignment.
I do have a question about that. His particular example. Let's say I'm going to do exactly what he was going to do, but instead of an ovation or doing exactly how he went, let's say you're the owner and I came to you and I bought interest in your property. And I'm technically owner. I bought 10%, 5% of the deed or whatever. And then I go to market. Am I good then? Technically owner. Is that just a way to skirt? Because you can do that. You know, can I just buy interest in this property?
Can you buy an interest
and then market
sell and market your own interest? Well, you would not be. Well, let's see here. Let's see.
I mean, I know a lot of people that do that. I mean, you know, it's
Can you say that again? I'm sorry.
you can buy. So, for example, let's say there's a property and it's 87 acres, and you got to go find all these acres. You got to get 87 people on this property. If you can buy one person out and be one of the 87. You own the property. You just own 187 of it.
Mm-hmm.
What I'm saying is, can you go to a seller, buy 5%, 10%, whatever it is, give them the money. You own it on deed, on record. They still stay in the house. You put the money in. You fix this thing up. Put it on market. Done. Done. All good. I mean, I know people who buy interest all the time who go. The last deal my buddy did, same thing. He just did a deal in Huntersville. 42 acres. Just a lot of acres. You know, like.
So the answer is maybe.
That's all I mean.
It's very fact intensive. So I'll give a couple scenarios which I think maybe it would work and maybe it won't. So I think it would work if it was you owned 5% and there was one other seller and they owned 95% and you guys sold the property together and then you got paid your 5%.
5%.
That's right, because you're not soliciting the seller. You're not selling a contract. You made a contract, the contract is done, you bought the 5%, whether you bought it or gave it to you, that would be fine. I think it would not be the same if you owned 5% and then you went out and solicited other property owners as sellers, because technically you still be buying their interest.
Say that second part.
Sure. You find an heir, one of 8, and you convince them to sell you their 1/8 interest. You didn't have 1/8. Everyone else is not on board. You have to go after them and say, I'm going to give you $10,000 for yours.
Yes.
Sell it to me, sell it to me, sell it to me. Oh, negotiations, I need this contract.
Yeah.
And then they say, sure, we'll do it. And you have to then assign that contract. Is that what you're saying? That would not work.
I understand. I understand what you're saying. Okay.
Off of that, would a closing or what would need to occur to obtain that 5%?
I don't think a closing would need to happen. I think it would be a deed.
Yeah, just contract.
A deed.
Contract.
A deed.
Right up again.
A deed would have to be, because that's the only way you can be a bona fide owner is by a deed.
Quick claim?
Right, you can get him to drop a
Recorded deed or unrecorded?
Yes,
Okay.
recorded.
Definitely.
North Carolina, you don't have any interest until the deed's recorded. We're racing to the state.
Sounds like the best way around it is to.
Real quick,
Yes.
can I ask you a question? When you do work on a property, how do you secure the funds that you're putting into that property?
We do billing,
You do what?
securing, like, say I have 20 grand in the property
Yeah.
and they flake out, we do a billing. And then
Billing?
like a bill.
Oh, like hope and pray.
Yeah.
Okay, hope and pray. So
put a
why,
lien on the property.
years ago, okay, I was gonna say years ago, I had several scenarios where I was going into people that couldn't sell their property because they needed work done. And at the time I had my GC license. So I would go in and form like a partnership with them on that property and say, okay, I'll put $25,000 worth of work into your property in exchange for a lien for X amount, and then have that lien recorded day one before I start the work, so that I'm always protected, because there's nothing stopping them from going behind your back to sell that property before you get your lien in place. So that might be a better way for you to handle that in the future. You can make a deal with them that, look, we're going to pay, we're going to spend X amount of dollars. If it's less than that, then we'll, rebate that off the payoff. But that way you're always protected and you're not worried about not getting paid.
The lien up front.
Correct.
There's also leniency, if you guys have never heard of it. It's a lien filing system in North Carolina. If you're a GC, you probably are familiar with it. If you're doing work for an individual, you can get an appointment on leniency and then file a potential claim, and then they can't sell that property until that claim is taken care of, if you're doing work on it.
It's called leniency?
Leniency.com.
You have to designate a lien agent every time you pull a permit.
Yes. So, but that, it ensures, as an attorney, when I'm doing closings and title searches, I check leniency every single time. If there's anything on leniency against that property, I say, hey, you need to go take care of this before you sell your property. They have to release it. Yes.
I'm a general contractor, and you can put liens on properties without even having the owner know about it.
Yeah, but that's kind of,
like
you saying if you did work and you're going to put a lien on it?
Like I build a new construction home, full permits, I have to do a leniency.
That's right, yeah. We're talking about the
So
same thing.
automatically, you can lock the lien in on the property. Until
Yes.
you build it and you sell.
That's right. Leniency is very friendly toward contractors because a lot of them got burned. So it's a good tool, and it helps me do title searches as well. So I love it. What else? What else we got? Okay.
On the lien thing, I hired a builder and I kind of got burned by them. I had paid the builder, but they hadn't paid some of their subs.
Yeah.
And they're supposed to go to the lien and see thing to file their claim of lien on funds of the builder, but 2 of them just went and put claims of, went to the courthouse and put liens on me, or claim a lien on me. What's to prevent them from doing that? They're not supposed to do
Unfortunately,
that.
there is nothing. It's still not right? Anybody can go to the courthouse and file anything. It's a matter of what sticks and what's good and what's not.
But I still have to go to court to defend that.
Yes.
The way I think it's supposed to work is they fully look at the permit on the job site, put the lien, they can find it, and they're supposed to go on when the lien
They're
is
supposed to.
Yeah.
So what does life look like for wholesalers after this passes. I think there's a pretty good chance it will pass. Maybe it'll be a 7-day period instead of 30, which will be a lot safer for everyone. If it does pass, I think, especially in the 30-day range, it could change everything to be an A to B, B to C closings to be safer for everyone. In that, as an attorney, even with assignment contracts, I have a ethics opinion that controls what I do. It's Ethics Opinion 2021, Ethic Opinion 1, Contemporaneous Residential Real Estate Closings. And it has to do with what I have to do and how I can represent A, B, and C in a residential closing under an assignment or an A to B contract. And basically, in an A to B, after this passes, A to B, B to C, C has to know at the time of representation that B does not own the property. That's one. They have to know that a purchase, basically what the purchase price would be from A to B, and that's about it.
They have to know the purchase price?
If they ask, I would have to say, this is what your property sold for last.
We're on the double blows.
A lot of times, if you think about it, investors, they're not dumb, right? They know that you're getting this property for them, and if they don't like it, then you're not going to sell them the property. But there are certain ethic opinions that are affecting attorneys on this as well that have recently been updated or adopted. Right? So if I'm doing an A to B to represent, so this would be totally different if I was representing B and some other attorney was representing C. It doesn't apply. It only applies to me if I am doing both A and B. That's right. Which is normally how it happens at one law firm. So there is certain things as an attorney that I have to tell people when I'm representing both parties.
Is that something that came from the bar, or is that something
Yes. So it's an ethical bound for me, and if I get caught not doing it ethically, I can lose my license. And A to B and assignments currently are also similar. If a assignee if assignee says I need my contract that I was assigned, they get the contract. If they want to see both sides of a settlement statement, they get to see both sides of the settlement statement. That's their right as an assignee, and I can't legally keep that from them as an attorney. And I tell the people I deal with, I tell them this, and they are safer because of it. Because often, if you're dealing with someone shady like that, it's bad. So I try to not only make sure that I'm doing my job right, but I protect my wholesalers, my assigners, and my realtors, and my contract people by making sure they're doing things right too. Because I've told multiple people I've worked with that I can't do that. Like, oh, please let me send them the contract. I need to redact this, and this. I said, you can't. You've signed the contract, you need to do that, or you're going to get in trouble, and you're going to go to court, and you're going to get charged 3-time damages for lying under a contract.
So it's technically, like, let's say if I'm assigned, and back in the day, I didn't been assigned. What I would do is I would redact the price, and I would wait until closing day, or whenever you sent them to HUD for them to see it. You're saying it's bad if I black it out early on?
That's right.
I'm not supposed to, oh, shit.
So, and I still see it. A lot of times the way I see it is they say the full purchase price is, the full assignment price is this, and it includes the purchase price and a fee. And then, the C would have to ask me for the contract, and I would say, here's your contract. And then they would see the purchase price and know your fee. A lot of times people aren't stupid. They know that you're providing a service and they're getting this property for the price they're buying. Some people get upset with that, but you probably don't want to deal with people that are upset with that kind of stuff.
But just for argument's sake, the only thing that's really getting hurt on the investor side is ego, right?
Most of the time.
So
sometimes you have.
So why would it bother an investor outside of his ego getting bruised that he didn't negotiate a better deal?
So I've had a couple instances where buyer C will try to go behind assigner B and go to A and try to get a better deal.
Absolutely.
Right, but that's bad on them.
It is.
Yeah.
But it still hurts the assigner for not being there.
Tommy, that's most guys. That's why I stopped doing assignments. That's most guys. Believe it or not. If it's the number is about 20 to 25. If you consistently show somebody something above 30, 40 grand, that's not smart. I have had properties under contract, drove by, I seen the guy sign them. I lost the deal somehow, drove by, I seen the guy sign them. Multiple times.
Yeah.
It's so.
Now, as you have you had a contract beforehand, so you have rights to enforce that contract to keep it from being sold. Or to sue them for damages under that contract because they went behind you. There's still good contract law, but it's not always worth it.
If you sue them for a contract that you had previously, somebody undercut you and does a deal with them, and you get like the full entirety of what you were gonna make.
That's up to a judge and a jury.
You're showing up to court as a wholesaler.
It's always going to be less your attorney fees as well.
Showing up to court as a wholesaler, you typically are not going to be favorable. I had a couple of lawsuits with MB Realty years ago. You are bingo. It's if you show up as a wholesaler in front of a judge, good luck, buddy. It's not worth that. Take the L. It's not worth that.
We've done well in our specific performance lawsuits.
But you know what you're doing. Good contracts, and you have the ability to close, and you can show proof of funds, and you actually can prove you had intent to buy it. Most guys are picking up 10K assignment, 20K assignment. They can't show intent they were actually going to be able to close. So that's the problem with the lawsuit, and that's what that was me years ago. I did a deal with Nasser. I'll never forget it. That was the first time I ran into MB Realty. They were very, very shady. MB Realty was going around. They would go to foreclosures and they'd pay them $500 and they would get rights to list their property for 100 years.
Yes.
For 100 years.
I think they got.
Exactly. They did. He sent me the whole lawsuit. But and even if it sold off market, a lien would pop up. And you'd be making 20 grand, and some realtor was supposed to get a $12,000 commission. You go, this motherfucker. Like what? And it was a lawsuit hell, and I know 2 lawsuits of that shit. And so that's my point. Is you can go sue, bro, but.
Well, that's just not working.
Yeah, not as wholesale. If you can sue for a specific performance and you can show intent you were going to buy and you had, then you go run it. If it was a good deal. But most of the time,
yeah, I've heard that too. Unless it was like a big fee.
Yeah.
That you're fighting, but
You was gonna walk away with 100 grand. Yeah, go get that. Go see.
But once you file the list pendants, they can't sell it, so they have to come back to you.
It's very true.
Yeah.
And I've seen where people are going like, I'm in some mastermind groups. They're like, our clouded title still, the property was still sold around the clouded title.
Yeah, but that's only if you go to certain attorneys. we know that. We know who that is. We know who those people are. You go to him, it will happen.
Yeah, I mean, I can't do a closing in 24 hours, but I'm sure some of you guys.
You're funny.
I think it says enough that everybody.
Exactly. There's nobody who hasn't been screwed over by those people, eh? Ooh, that was funny. So
Can you tell us more, so you do quiet title,
Yes.
color title, adverse possession?
We do. Mm-hmm.
Okay. How many, messy errors and judgments and stuff like that?
How many? Give me.
We did one with 38. That was probably.
I did a deed closing. It took me a year, 38 errors.
Yeah.
But I didn't have to do quiet title. I actually found everyone.
38.
My deed recording fee was $141 because it was a 38-page deed. But let's see. You guys might Jeff Johnson. I work for Better Path a lot on all their closings and their hard deals. So I just did one with over in Union County. It was 2 lots. We did a quiet title action for 5 heirs that beat out 16 others. So they were able to get it, and they worked that into their pricing. They were able to buy it, build homes, and still make money after the quiet title.
Can you explain to me what a quiet title is? I don't.
Yeah, sure.
I hear this and I know kind of, but I need to know.
So quiet title is a suit that gives a court order at the end saying who the owners are. So if you are unable to locate owners, you have to go in front of a judge, and a judge will then declare who the owners are after you do a title search, file files, serve everyone that you know of, hire a guardian ad litem for unknown heirs to say that they also couldn't find anybody, publish it in the newspaper, file files, pay your attorney, you get an order saying these 5 people are the heirs, and then you can then buy it from them.
I find a property today, I go into contract. About how long, and let's say we're going to start quiet title process, about how long until we're
Great question. There's no good answer to that. Could be 6 months, could be 2 years. People could fight it, and you may lose. An heir could come back and say, my peepaw actually had this will, here it is, I own more than that they say, it's my land, and then they'll be added, and you may not be able to get it, or, it's not always there's no certainty in that, whereas a private sale, you have certainty, you can control it. It's always up to the judge if other people get involved. And when you get the pieces of property, people have any money, they'll hire an attorney to try to fight that as well, to make sure their interest is protected.
You can pretty much find everybody, so that's
Oh, really?
a rarity,
I'm gonna
yeah.
have to call you.
Yeah, I can find almost
I
anybody.
got one. It's
I'll find them.
yeah, it's a hell of a deal, but I can't find them to these streets.
But we did have one real quick where no one had saw the air for like 17 years. We had to check all the homeless shelters, hospitals, we did this whole exhaustive search, and we did the quiet title, they gave us his portion. So there are a few things like that, but pretty much you can find people, you can find anybody.
Have you run into a situation where there's absolutely no one to find?
What do you mean?
There's always an error.
There's always someone.
There's never, I see
Someone will say, I own that piece of property, or their name will be on the tax bill, or something like that.
So I've had two in Mecklenburg County, which one the city tore down, and the other one I haven't followed up on in about 10 years. But there was no one to find. There were no family members at all.
At that point, what will happen is it'll go into tax foreclosure, the county will sell it, and then someone will own it.
But typically it goes up and stuff like that. I've never seen one. Have you ever seen one that didn't have an error?
One that they had deeded it to a fake name. Remember that
Yeah.
one? That was like.
Yeah, you deed to a fake name, you have that deed for 7 years, you have color of title in North Carolina, and then you can file a claim with the court and say that's my property.
That's a bunch of those. I've seen that a lot.
What? Say that again?
We'll have him go first. And then.
No, go ahead, please.
So in North Carolina, you have 7 years, what's called 7-year color of title. That means if you have a deed with your name on it, and so, an example would be, your great-grandfather owned a piece of property, but you can't reach in your relatives, you're pretty sure you're the only heir, you draft a deed from yourself to yourself on that piece of property, and you hold that property for 7 years under that deed, you have what's called color of title of North Carolina, and that's assumed ownership. And then you could go to a court and say, please make this real that I own this property, and the court could adjudicate that you are the owner because of that 7-year-old deed.
So who's paying all the taxes on that period of time?
Well, hopefully the owner, because that's going to be part of their 7-pronged test to show that they are the owner.
You have to do stuff as if you actually, you have to treat that like it's your
That's right.
property once you do that, right?
Yeah, because that's also part of the 7-pronged test for adverse possession,
Yeah.
But that's
which is
20
very
years.
hard
Yeah.
in North Carolina, nearly impossible.
Don't say that I'm doing right now. We're doing an adverse possession, tacking on to another owner's claim.
I didn't say it was not possible.
Okay.
I said it's almost impossible. Very hard test in North Carolina. What else?
Can you cover the clause around deposit? Is it due diligence money or earnest money?
Yes, so it's earnest money, which in my interpretation is going to cover any money that you as a buyer give to the seller directly.
Oh, that's deep.
Call it whatever you will.
Really?
Due diligence is a type of earnest money. It's just something that people came up with new. It's not in all states, but in my interpretation, if you give them $1,000 and call it, fund money to go drink with, but it's for the property contract, they're going to be able to keep that. Also, sometimes you give the attorney the EMD, right? It is unclear in this bill whether or not the EMD would have to also be released that you gave to an attorney to hold during that 30-day period.
Interesting.
Because there's nothing in there, because as an attorney, I'm holding that money for the seller, right?
Being that it's unclear, if you put in the contract, hey, post 30 days or whatever, I get my money back.
I don't think so.
You still can't.
It doesn't say, it says EMD. And it says this is a non-waivable 30 days. So I would say that is not possible.
So what's stopping the seller from reselling the property
Nothing
over and
at all.
over?
That's right.
So that's a whole business they're starting up right there.
That's why, it's a way to keep people from doing assignments.
Because, when properties are people have been doing that with due diligence money. Sellers would just keep the due diligence money and relist
It's really
it.
bad at 2018. People making $40,000 a pop, and just there's nothing they can do about it.
Yep.
It's another deterrent from doing these type of contracts.
So sellers would take the DD money and just decide, hey, I'm not selling anymore?
Yeah.
And still, they can keep.
Well, if it's every 7 days, you can do that every 7 days for the next however many years you're alive. And just get another check and another check and another check.
But it's not like.
And it's legal.
It is. It's completely legal. But,
Absolutely legal.
You guys are the professionals, right? You're not going to sit there and give people thousands of dollars during the 30-day period. You would draft a contract and say, great, here, 30 days, I'll give you $1,000, right?
Yeah.
Or 7 days, then I'll give you your $1,000 for EMD. And that's when you would give it to
You
them.
can make a due diligence period like 14 days, which is past that 7, and then like, hey, when the diligence is over, I can give you your EMD, and then, right?
As long as you're not giving money to the seller directly during that period or to an attorney that's holding it on the seller's behalf.
Exactly. It's in like
So hold on to your money. You
Yeah.
say, after a 7-day period, contract review period, maybe that'd be a great wording. After the 30-day, or you can just call it whatever they call it in the statute, 30-day cancellation period. After the 30-day cancellation period, 7-day cancellation period, the buyer will then proceed to deposit $1,000 of EMD with their attorney or hand it directly over to the seller or something like that.
I like that a lot.
The way I'm saying this is, all that stuff is kind of irrelevant because
Basically,
you really can't assign contracts.
You can assign contracts.
Yes.
You just have to be a broker.
But I'm saying, and then your brokerage firm's going to say,
They don't want some money, man.
list it.
Or that.
That's right.
So it's just double close, or
That's right.
and then don't worry about that.
Or have
That's right.
some work under,
Work
work
under
a deal with a broker,
Yeah,
you
we're
know?
on a broker for
Yes, ma'am.
What if like you have a scenario where the wholesaler can get their fee, their whatever they trying to make
You just want to do the
outside, like before closing, and just leave the buyer and the seller on the table?
Yeah, you definitely get in trouble for that under here. It still falls under the thing whether or not it shows up on the settlement statement. Good question, but it still falls under that, and you might get even in more trouble for trying to hide it. What else?
Let me ask you this then. I've also done deals where, I mean, you can find it, but like, for example, Tommy's buying something. I literally got contracts, put it directly. I signed a contract with a seller. I put Tommy's company on it. Tommy signed it. We sent it in to you to attorney. I'm technically not in it. I'm in the email chain, but I'm technically not on contract. Tommy closes, and on closing day, I walk in Tommy's office and pick a check up for what we agreed to.
What services did you provide?
The dollar bills in that gun and I shot it at
See, a slingshot would have been cooler.
So I was not technically part of the transaction on record or anything like that.
What services did you provide?
Connection.
It was a referral fee, and this
So you solicited
I didn't
and
solicit
marketed
anything,
it?
bro.
Well, I see.
I
In
see-
this scenario, I'm your attorney defending you
Exactly.
against consumer protection laws. So I'm going to ask you.
Exactly, because
Tommy just likes you.
Because I'm trying to figure out how you protect how I protect
That's
myself.
only a problem if you get caught. But if you get caught, you're going to be asked those questions, and Tommy's going to be brought in, put under oath, and said, "What did this guy do for you?" And Tommy's, and if you lie under oath, you're going to go to jail.
So I just gotta
Tell me
make
what
sure
did you
this
do.
guy doesn't come to these meetings.
That was the first question I asked him when I asked him to do this.
Because I've done that.
Because I literally just finished a deal with Christian where they set everything up, I closed the deal, and then just cut him a check.
Same thing I do all the
Why
time.
can't Tommy 1099 me if I do that deal and trust him? Hey, there you go. He can 1099 me as
For
a.
what services? What did you do for Tommy?
So I'm glad this.
I'm doing research, right? And I'm showing Tommy, hey, here's, check out this.
We can come up.
I'm an analyst.
That's all I'm saying. We can come up with an analyst. Professional analyst for Tommy.
Sure. Did you solicit the homeowner? Did you market it? Did you sign anything? Did you do any offerings, negotiations, or deal in any kind of contract?
Yeah, I solicited the
No,
homeowner.
your answer is no, I didn't.
He just gave you.
But I'm just saying, right? No, but hey, I talked to
If
the
you research-
homeowner, I had intent to buy
No, then
it.
you fall under this. You talk to a homeowner.
And what, I can't tell, like, if I go to your house and wanna buy your house and say,
You wanna buy your house, you fall under this.
it's not a fit for me, Tommy, do you
You're
want
not
this
saying
house?
it right. You said, I researched the property, I found this property, I didn't talk to them. Tommy, call these people and offer them some money.
Yeah.
Then you're just doing research, and you're not following this. Tommy's gonna pay you for his research.
Research.
Well, no, he's doing research. That's exactly what he's doing. It's not trick wordplay. He's doing research. That is legal. That is not an assignment. You're helping Tommy find deals. You are not involved in the deal. You're researching things. It's no different than me going to the courthouse, doing a title search and saying, yeah, this deal is good. Call these people and go through with the deal.
Okay. That's like,
So that would be the way out?
It's not a way out. It's not the You guys are setting yourself up. I'll have a couple of civil attorneys ready to go.
I don't even know what assignments are.
That sounds like
Stephan, what's the definition of for your personal residence? Your family, your extended family, relatives?
This is personal use.
Yeah.
Great question. What is the definition of a personal
use residence?
used as a residence of the soliciting party? I don't know.
Could
It's
my
not defined.
family, my long lost brother live there?
Yeah, maybe. It's not laid out any further. It would have to be litigated.
But like he was saying earlier, if you intend to live in that house and after you close 5 minutes later, you're like, oh, wait a minute, they don't have a doggy door. I can't move in there with my dog and decide to live somewhere else. They can't prove that your intent wasn't to actually live there.
Yeah, but intent is also, you've got the giggle test.
Oh, I
If
gotcha.
you can't
I
defend
gotcha.
that in court
Yeah,
without
I gotcha.
without giggling.
Yeah,
Yeah, so why put yourself in that position?
yeah.
So I personally haven't done any double closing. Are there any disclosures, or what does that look like when you're setting that up with the?
Yeah. So a double closing. That was in talking with this with a couple other attorneys. We decided that the disclosure, if you are A to B, you're B. You don't really owe any extra disclosures to A at all. Your disclosures is to C. So you have to tell the end buyer that you do not own the property at the time you're selling the contract, but you intend to by the time closing happens. And they could also potentially be needing to know like I think maybe the purchase price from A to B, if they asked.
They only have to know the purchase price if I don't currently own it.
No, this is the back-to-back closing.
On the double close, do they only have to know?
If you buy the property, close it, and then market it?
What if I own, again, if I own 5% of the property? Again, if I buy interest, can I get around this if I buy interest, is my question.
What are you gonna do with the 5%?
Nothing. I'm gonna try to sell it, but what I'm saying is, can I get around these laws if I own part of the property, technically? That's what I'm asking.
No, you would still have to tell them you did not own all interest in the property.
So I get another scenario. I buy your house, or I contract your house.
Contract it.
Tommy's gonna buy it from me.
Okay.
Tommy and I decide we're gonna create an LLC, Tommy LLC, that's now gonna buy your house. Tommy then buys me out of my LLC after close. For agreed upon amount.
When do you get paid?
A couple days later.
And what are you purchasing? Or what is Tommy purchasing from you?
We're gonna
Interest in the LLC.
We're gonna, interest in the LLC.
Then you didn't have anything to do with the sale of this property. You got paid because Tommy purchased your interest in the LLC. That was the transaction. I think it would be separate and apart from this.
One thing that I want to just say, so like, one thing that my CPA will tell me is that you're making all these chess moves in order to save a little bit here, a little bit there, and to like, you're putting a lot of thought into something that might not be something that's real in the future. You know, like if you're just like, you know, constantly in the thought of how do I work around something instead of just, because like when the interest rates spiked in 2022, you know, they went up. My thought was, I'm going to go against the system. I'm going to create these tenant in common things with 1031 exchanges so that I can buy these properties. And then it just got so convoluted that I was like, why don't I just do midterm rentals? I can make more money every month so that the interest rate hike is irrelevant to me because I was making the cash flow that I needed. So one thing that I would say to everybody that are asking these questions that are, you know, that may be helpful, but there's a lot of pieces that need to fall into place for them to be successful, is that try and find a way that can work at scale. Because are you going to find enough people that are going to want to be in an LLC with you? Are you going to find enough people that are going to sell you 5% of their house?
Do you want to risk an attorney breaking that down and saying, oh no, actually you did this because you were trying to get around this law? Because you're building a lot of effort for still having a high risk tolerance.
I know in South Carolina you cannot market a property, and that is, the LLC is the way to go. It's like it skirts it.
Too, yeah.
It skirts it, you know, like, hey, look, I'm not marketing it. You know, Tommy and I are partners. Like, I didn't market to. So that's why I was wondering if it was going to be the same.
Not under this law, but you know, domino effect, that might be next.
How about a trust?
What about it?
Do the same scenario with the trust.
I guess. It's still an entity. You still be buying out a trust. Trusts are weird things. You have trustees and beneficiaries, and it's not a normally traded business entity. You might have a lot more trouble with that. It wouldn't change the equation though, if you were able to make it work.
It sounds like probably the best solution, you need to have transactional lenders in place and buyers in place.
Yeah, pretty much.
Yeah.
So you can double close and somebody.
Double closing is safe. It's effective both legally, risk-wise, and the only hurdle is you have to have that money for your closing at the time of closing. That's where it gets hard.
Private lenders and hard money, so you can wholesale it, buy it, and then go ahead and list it instead of doing like a novation. Well, through a broker, because then they can like, it's your property to actually put it out there. Like if you wholesale it, because then you buy it with hard money, then you have a broker or agent to list it for you, and you can do minor fixes.
Why would you need a broker to list it for you if you already own it? You can sell it by owner.
Well, if you want to market it to a high level.
Okay, I get what you're saying, yeah.
Yeah. Or you can sell by owner. But if you want to put it out to the eyes, then that would be a safe way, and it's probably a better way to do it. So it's, sort of thing. A few ways around it.
What else?
No assignments, I think we got it.
Do you see this changing at all?
Before it gets passed?
Yeah.
Well, we see there is some lobbying still going on in the Senate. There's definitely a possibility. 30 days is a pretty high tolerance. It would just pretty much wipe this out. So, I don't know. Maybe.
I guess it's just a general question. Are you guys familiar with any groups that have gone and petitioned and protested this group that you guys would maybe recommend reaching out to? Because it could be beneficial to at least change some of the rules. Because obviously the 30 days sounds kind of ridiculous. Obviously you said it's 7, but I would assume that at some point there was pushback. So I would be interested in potentially getting involved.
Nasser? Yeah, Tony Robbins, him and Tony Robbins.
Yeah, Tony is who, you have it on calls. And, we actually put in, we gave Tony money for a lobbyist. If you would have saw the first draft, it was
crazy.
Yeah.
I remember him telling me.
If you weren't, you couldn't even buy a house.
It was crazy.
If you didn't plan on living there.
Wow. Tony's done a lot of, Nas and Tony have done a lot, so if you ever want to support them, that's what it is.
Okay.
What else? You got an attorney here giving out advice. You don't even have to pay me. Got paid pizza earlier.
My closing fees are gonna incrementally grow up for each one, so.
Oh, by the way, I'm
Take
not your
advantage now.
attorney. You haven't hired me to give you any advice. You can't go and say, hey, my attorney told me this is now legal in this matter. I'm just talking to you guys as listening to me babble on, so.
So let's say you buy a partial interest, you can't do color of title after 7 years, can you?
Only for that tiny parcel part of the
So
interest.
you're better off deeding to yourself or something like that,
Really
right?
has, I'm sorry, go ahead.
And then waiting the 7 years, right?
So color of title is only after 7 years with your name on the deed.
Your name on the deed.
That's right.
So what stops people from creating a deed to themselves on your house and waiting 7 years?
I mean, it doesn't give you title. It just gives you basically the ability to go up and say, "Hey, judge, my name's been on this property for 7 years. I'm the owner of this property." Instead of having to wait for adverse possession for 20, it kind of shortens that. That's how we got color of title in the last one. Someone gave themselves a deed 7 years ago. The last person that owned it was their great-grandfather, so that helped wipe out the rest of the other heirs that were underneath it. So it's a tool you can use to give yourself the right to go to a judge and say, hey, I own this property, here's a deed, it's been 7 years. No one else is in the chain of title. The last deed was for my grandfather in 1910. I own this property, and the judge is gonna go, okay, and it helps you get it faster.
So if you got a messy title that no one's gonna come back on, you can just deed it to yourself, that and then keep it 7 years.
If you're the great-grandchild of Bertha Rose and she owned the property in 1910, you did a deed 7 years ago to yourself, then that could potentially give you a stronger leg in court to own that property.
But you just can't.
It's not an automatic thing.
Oh,
But he has to pay the taxes and everything, right?
Yeah, or the court, the taxes don't need to be paid.
He would have to pay them.
That would be a stronger case for him in court.
Yeah.
What else could you do to show a stronger case for that?
Live on the property, put up a fence, get mail there, make improvements, property bills, water bills, anything that shows ownership or residence. All right. Well, I appreciate you guys having me today. I have only like 8 cards because I didn't know how many friends Tommy actually had. So. Oh, okay, good. I should have brought more for his acquaintances. I only brought 8 for his friends. So.
I have much less friends. Not that anything against them. It's me. It's not that.
I believe it.
Yeah.
You have to put it on the table when we take photos.
Yeah, of course. And then.
Although I did send you guys cookies, so are we friends now?
We are.
You're my best
Tommy,
friend.
can I give you my address? We want cookies too.
So I'll put my card there. You'll have my email, my phone, direct phone number, and texting number. If you guys ever run anything or you just want to run it by me, you're more than welcome to shoot me an email or a quick phone call.
Thank you.
Thank you. Thank you so much.
Check out foundationsrealestateacademy.com and don't forget to subscribe. We've always got more stories to share.